Mr. Abraham, are you ready?
Yes, Your Honor.
All right, who's up first?
Good. We can start with Mr. Alexander.
All right, Mr. Alexander, if you'll come up, sir. This is cause number CR 21-275 for pretrial. Go ahead, Mr. Manning.
Yes, Judge, we've reviewed the discovery. We did have a question on and clarification on some of the discovery. The state got back with us on that clarification. However, at this point, we're still awaiting an offer for Mr. Alexander's case. We're ready to move forward to docket call.
All right, does the state intend to make an offer?
Yes, Your Honor. I'm sorry. I thought I had, but I'll get with Mr. Manning and make sure that that we're clear and that we're communicating.
All right, court will set Mr. Alexander for docket call. You want that July 11th date, Mr. Manning?
Yes, Judge.
All right, July 11th at 1:30.
Thank you, Judge.
All right, who's next?
Next, ready on Mr. Daniels.
Robert Morrell Daniels, CR 24-47 for pretrial. Go ahead, Mr. Manning.
Yes, Judge. Mr. Daniels has cases both here in the 294th as well as county court law. I'll be filing a motion to have those joined here in the 294th. Additionally, Judge, at this point in time, we have no contested pretrial, and we'd like to move forward to docket call announcement.
Your case down in the county court of law, are you representing him on that?
I am, Judge.
Okay, and is there any issue in that case that we'll need to tend to up here? Or you think both cases are ripe for docket call?
Both cases are going to be right for docket call, Judge. This is a case that, or this is a situation where there were multiple cases that arose out of the same incident or occurrence. So we'd be able to handle both of those.
Okay. All right, court sets Mr. Daniels then for docket call on July 11th at 1:30. And once that's transferred up, I'll sign that order.
Thank you, Judge. Additionally, Judge, I would note for the record, at this point in time, we have not received an offer on any of Mr. Daniels' cases. I believe my client is disinclined to take anything, but I would like something just for the record that we can say, hey, something's been extended or offered.
And Your Honor, specifically going to that point, we were waiting. There were some cases out of Travis County. My understanding was that we were going to match what Travis County was going to do, but I have not heard anything about the pendency of those cases. So with that information, we can go from there.
Thank you, Mr. Hartwell. All right, Mr. Daniels is set for docket call July 11th.
Thank you, Judge.
All right, who's next? Thank you.
Judge, we're going to be doing a plea on Mr. Davis. I don't see him in this group, so I will get his paperwork done in just a moment. We're ready to reset Mr. Deal's case.
All right, Dean, Evan, is it Dial or Deal?
Deal.
Deal.
Deal, Judge.
All right, thank you, Mr. Deal. Come on up. CR 24-49 for pretrial. Go ahead, Mr. Manning.
Judge, no contested pretrial matters at this point in time. We have reviewed a sufficient amount of evidence to proceed. At this point, we'd ask to be set to docket call, and we are awaiting an offer if one's going to be made on Mr. Deal's case.
And Your Honor, this case was indicted by Ms. Curry. I'm not sure if she intends to keep it or transfer it to me or Mr. Hernandez, but we will be in contact with Mr. Manning.
All right, court sets Mr. Deal for docket call July 11th, and if the state makes an offer, if it'll just be made in such a time that Mr. Manning and Mr. Deal can give serious consideration of that, I appreciate it.
Next, Judge, we're ready on Mr. Dole.
Austin Tyler Dole, CR 2451 for pretrial. Go ahead.
Judge, there is no contested pretrial issues. I have discussed this case with the DA's office on multiple occasions regarding some mitigation or exculpation from their complaining witnesses. I have not had a chance to talk about whether that's going to impact any offer, but we would like to go ahead and keep this moving towards trial if the state intends on holding on to this case. So we request it be set for docket call.
All right, court finds that there are no contested pretrial motions, sets this matter for docket call on July 11th at 1:30.
Judge, looks like next one we're gonna be ready on is Mr. Eubanks.
James Henry Eubanks, CR 2452. So Eubanks also set for pretrial. Go ahead.
Yes, Judge. Mr. Eubanks and I have reviewed the discovery. We have no additional requests for discovery or motions on discovery at this point in time. We received an offer on the case and my client is considering that offer. Would request to be moved to docket call.
All right, court sets Mr. Eubanks in for docket call July 11th at 1:30.
Judge, next ready on Mr. Gilchrist.
Warden Alexander Gilchrist, CR 23-233, CR 23-213 for docket call. Go ahead, Mr. Manning.
Judge, I learned recently that these cases are being handled by Ms. Curry or maybe handled by Ms. Curry. I've not been extended an offer, so we request an additional setting on docket call so we can see if this case can be resolved without taking up one of the trial settings.
All right, so you're requesting a final docket call?
Yes, Judge.
All right, you want that July 11th date as well?
That'd be fine, Judge.
All right, court sets Mr. Gilchrist for final docket call July 11th at 1:30.
Thank you, Judge.
You're welcome, sir.
Judge, next we have Mr. Glasgow.
Michael James Glasgow, CR 23-215.
Judge, we have reviewed discovery, have no contested pretrial issues. Request to be set for a plea on the July 11th date.
Do you want to do the 11th or do you want to do, we can do something sooner?
Judge, he needs to take care of some business in Henderson County before he's able to go forward with his plea here. And he's currently being housed in Henderson County. My understanding but prior to today was that he had gotten that stuff taken care of. But there was, as often is in court, there was something that came up the prosecutor needed to check out before they go forward. Mr. Glasgow assures me that they're ready to move forward down there on the 17th. And so I think just out of abundance of caution, if we can get him back up on July 11th, that should give them plenty of time to do what they need to.
All right, court sets Mr. Glasgow then for plea on July 11th at 1:30. That's in each case, CR 2419, CR 2420, and CR 23215.
Judge, at this time, I believe if I could have some time to speak to the remaining folks, I think I'm ready for the next batch. So if you would like to take a recess, I will get the paperwork started on those that are ready to do paperwork, and speak to those that need discussion.
Okay. Is Mr. Schmidt ready on anybody, Ms. Abraham?
Judge,
Or the
Mr.
group?
Schmidt, I believe reset his case this morning.
Oh, that's right, Lisa Langley.
Yes, Judge, and we don't have any of the females here. At this.
Okay, so we don't have Kiara Kuntz also. And so Patty, Mr. Sean Story is appearing via Zoom today. I don't know if you're aware of that, but he's in the Zoom waiting room.
No, Your Honor, I was just calling his office.
Yeah, I showed him to be in there earlier. He's still there. So let me know when she's available and we can do that. So we'll go ahead and stand in recess and let Mr. Manning speak with the remainder of his
We
comments.
will go get her now. And I'll close it.
Hey, Patty. How long is Mr. Manning thinking? 15, 20 minutes, 30 minutes?
Judge, I believe we may have an additional plea. I'm not sure the DA's office is in process on that. So to give them time, I said probably closer to 30 minutes.
30 minutes? All right. I got a phone call I got to make. I just want to make sure I had time. So it's 1:50. We'll resume at 2:20.
I mean, you want us to go get the female and do Mr.
If that's not going to be too much trouble, then I'm
No,
sure.
they said she's just in detox.
Okay, yeah, let's go ahead and bring her and I'll bring Mr. Story in right now.
Okay. Okay, Your Honor.
All right, you're Miss Coons, correct?
Counts.
Yes, thank you.
Counts. I'm sorry. I looked at it and I said, that's spelled like counts, but as soon as I say counts, she's going to say Coons. I'm sorry about that, Miss Counts.
No worries, thank you.
All right, and Mr. Story, your attorney, there he is. All right, Mr. Story, can you see and hear us okay?
Yes, Your Honor. Thank you.
Do you see your client as well?
I do.
Excellent. All right, this is cause number CR 23-94, State of Texas versus Kiara Lachey Counts for pretrial. Mr. Story, have you received all of the discovery in this case from the state?
I have, Your Honor.
Excellent. Did you file any motions for contested pretrial hearings?
No, Your Honor, we intend to do an agreed plea, but I didn't know if we need to do a pretrial investigation first or how the court, and I'm still wanting to talk to Mr. Hartwell about that final plea offer.
Well, what we can do is if there's no contested pretrial, what we can do is set it for a docket call. And that would be the opportunity for y'all to negotiate between now and then. And then you could announce to me at that next setting, what if you want to plea, you could enter it that day. If she wants to set it for a bench trial or a jury trial, we can do that as well. So they'll give you a little bit more time.
Okay, so we don't have to do the pretrial investigation.
Are you talking like a pre-sentence investigation?
Probation, right? Yeah, I'm sorry. Yeah,
Oh, no, no. If y'all have a agreed recommendation to the court, and you're not pleading open, then a PSI would not be required.
understood, sir. Do you have availability on the 27th,
June or July?
June?
June, no, we are in a criminal trial that week. The next date I have available close to that would be July 2nd. It's a Tuesday.
I am not looking at my calendar. Is it possible does the court do any attorneys appearing virtually for a plea? Is
Uh,
that possible?
Only if you've already met with your client to go over all of the plea papers, have them signed, you sign them, go over if it's going to be a probation plea to have all the conditions. If you meet with her prior to and you go over all the paperwork and have it signed and leave it, then I'm fine with that. Otherwise, I do have some other dates. If you're not needing an extended reset, we have a hearing next week on the 18th. We also have hearings on the 20th of next week. But the week after that's our trial week.
Okay. The July 2nd will be fine. And I intend to meet with my client and get everything prepped in advance,
Okay.
if that's okay with the court.
And so you're thinking about appearing via Zoom for that?
Correct.
Okay. Yeah, I'm fine with that so long as she has got all of her questions answered and that you've already signed the paperwork where it's necessary and you do all that, leave it at the jail or turn it back into the state, then we can finish that out at the hearing.
Yes, sir.
Okay. All right. The court sets Ms. Counts for plea before the court on July 2nd at 1:30.
Yes, sir. Are we dismissed, Your Honor?
Yes, thank you, sir. Thank you, Mr. Story. I appreciate it.
Thank you, sir.
Hey, Your Honor, we'll see you at 2:20.
Okay,
Your Honor.
Ms. Karen, he has all his, people's info back in his cell. After the plea, you want him to go back and get that? Your driver's license. I pointed out. I'll ask. I think so. You're on. Do you have any more? Okay. No, go ahead. Then you push it back on. Okay. And how much longer?
They arrested me, when I took my probation appointment, and then I did 30 days there, and then stayed on it, and I transferred here.
If she's doing ISP. Is it worth giving a shot? Very good. Or so.
Is she?
No, they already have it. Are you reporting?
I actually have my page. So
Are you reporting? Yeah.
I don't know if they were gonna transfer it back to Smith or if they're gonna go ahead and let you on it. Oh, yeah, they do. I have a visa. I'm sorry, she is my new code. Thank you for my chocolate. But I do have my paper in myself.
Huh? Okay. I don't bother. Well, I'm not put that on. Let's see, we're not. That's how Mrs. Bryant brought up, the whole cell got housed. I don't want that to happen. You want that to happen? We're still waiting on Mr. Blunt's to do it, so. Is Ernst Berger here?
Yeah, we're gonna break.
He's very last.
Mr. Davis. Mr. Davis.
Yeah.
So he'll do that. And you want to.
Yes,
So you're gonna have to impact it over to Miss Griffin. Stop getting locked out before she. Yeah, transfer.
They're off. Okay, that's the important.
You'll have to come here to the foundation.
Okay.
In order for us to transfer your case to the. To do
So transfer the probation office.
that,
Yeah.
if that's where you.
Works.
You'll bring me your sheet that you put on or maybe. Yeah.
So.
Ms. Abraham, are y'all ready?
Yes, Your Honor.
All right. Who are we ready on?
Judge, we're ready on Mr. Graves.
Stephen Ford Graves, CR 2453. Mr. Graves set for docket call. Go ahead.
Judge, in requesting an offer from the state, they have indicated there may be some additional charges forthcoming, and they were unwilling to extend an offer at this point in time. We'd request that we hold off on docket call in this case so we can determine what exactly we're looking at and possible resolutions for that.
Mr. Hartwell, on behalf of the state, do you think you need more time than July 11th if there are new charges? I don't know if there's new indictments or if these are charges in other counties.
No, Your Honor, it is in this county. I think July 11th will be fine. At least we'll have a final word. I know Mr. Graves has been under an ongoing investigation. We should have a final word from the agency and be able to do an indictment if one is forthcoming at the next grand jury.
Okay.
So July 11th will be fine.
Okay.
Thank
Thank you. All right. Court will set Mr. Graves for additional docket call on July 11th.
Thank you, Judge.
Who's next?
Judge, next ready on Mr. Keith King.
Keith King,
That's
CR 24-59 for docket call.
Judge, Mr. King was extended an offer of 4 years deferred probation. That offer was had a deadline placed on it by the prosecutor that if he didn't accept it, they intended to withdraw that offer and also have any potential enhancements filed prior to trial. And speaking to my client, he is unwilling to take that offer. In addition, Judge, he requested a speedy trial. When I explained to him the trial process here in Manzanita County, he had asked to make his request to the judge to have a trial. Well, today is what he asked for. And I explained to him that was not possible. And so he asked to speak to the court about his trial situation.
I'm not really inclined to hear from Mr. King on what he wants. I've appointed counsel, you, Mr. Manning, so you can relay any legal arguments. I understand that everyone in that jail that's wanting a trial wants it ASAP, and obviously I'm trying to manage that from all the people that existed before Mr. King. But does Mr. King want a jury trial or a bench trial? I might be able to accommodate him if it's a bench trial, but if it's a jury trial, he's going to have to get in line and wait like everyone else.
Judge, we had not discussed the option of a bench trial. I will discuss that option with him tomorrow. And if he's willing to go forward with the bench trial, what dates would we be looking at for something like that?
I'll need to consult with Miss Taberham and Miss Barker on that. I'm just saying I know I could get to a bench trial before he'll get to a jury trial.
Okay, Judge. Let me weigh those options with Mr. King tomorrow, and I'll let the court know. But if we can go ahead and place him on the jury selection docket, with the understanding, as I've explained to him earlier, that offer that was extended for the 4 years deferred will be withdrawn, and the state does intend to file an enhancement if they get the proper paperwork.
Okay. All right. The court will then place Mr. King on the jury's trial docket today. Let's see. We'll set that to begin on June 24th. If Mr. King elects to change who tries the case to the court, then the court will reschedule that. Court finds that Mr. King has been extended an offer of deferred adjudication community supervision, that he's rejecting that offer today. And the court will not allow negotiation or acceptance of that offer after today. And what I'll do is at the conclusion of the docket today, I'll get with Ms. Barker and Ms. Taberham. And then what we can do, Mr. Manning, is try to shoot you some dates that we believe, and you, Mr. Hartwell, as well, regarding when we think that we could do a bench trial so that you can weigh that in your decision.
Yes, Judge.
Okay.
Thank you.
You're welcome, sir.
Judge, next, ready on Mr. Bobby Shaw.
All right, court calls cause numbers CR 23-118, CR 24-29, and CR 24-30, State versus Bobby Jean Shaw. I believe they were set for docket call on all three. Go ahead, Mr. Manning.
Yes, Judge. And actually, I believe Judge, Mr. Shaw has a fourth case. Sorry, I'm trying to check my docket real quick. I believe there's been a fourth case that's been indicted, that we are still in the midst of getting discovery for. And I don't see it on this particular docket. I know we had an arraignment on it previously, if my recollection is correct. Did we do arraignment on that? Excellent.
No, it was, I just caught it. Remember,
Okay.
I got it 30 days ago.
Judge, there's another charge that's out there that was arrest warrant that was done and executed at court last time. I don't know if that case has been filed yet or not, so I'd request additional time on Mr. Shaw's case.
Any objection from the state?
No objection, Your Honor.
Thank you, Mr. Hernandez. All right, let's see. Let's set Mr. Shaw out a little bit further. Mr. Manning. How about Thursday, August 1st? Are you available then?
I believe so, Judge. Let me double check. That'll work, Judge.
All right, court sets Mr. Shaw on all currently indicted cases for docket call August 1st. And then if there is an indictment on any other charge not reflected on the docket now, then the court will try to set that for arraignment on that same date.
Thank you, Judge.
Thank you, Your Honor.
You're welcome, sir. All right, Mr. Manning, who's next?
Judge, ready on Miss Hunter?
Rebecca Hunter. This is cause number CR 22-218, motion to revoke. Go ahead, Mr. Manning.
Judge, we've reached a resolution on Miss Hunter to per the probation department reinstate her. However, it because of the late resolution of Miss Hunter's case, me getting to speak to Miss Hunter and the probation department, it doesn't sound like we're gonna be able to have the paperwork done today for her case. I request that she be short set to next Thursday's docket, so that she's not dry sitting as long as possible.
All right, court will reset Miss Hunter for Thursday, June 20th. At at 1:30.
And Judge, if the state probation department are able to get the documents in sooner than that time, would the court consider signing off on this?
The court would, so long as the probation department is supportive as well.
Yes.
All I need is a-
Judge, Miss Burns says that all she needs is the withdrawal paperwork and she's ready to go.
I don't have to do anything.
Yeah, as soon as that's submitted to the court, I'll get that signed and we'll get Ms. Hunter out.
Thank you, Judge.
Well, it's, sorry. Nobody muted. It's going well.
Ms. Burns is trying to, overrule the printer over.
Sorry, you were cutting out there. I think y'all's connection's not real good.
Ms. Burns is
Having some technical difficulties.
She is,
fixing copier.
Ms. Burns is a technical difficulty.
I just don't do IT work.
Yeah, that makes a whole lot of sense.
Judge, we're ready on Mr. Davis's case.
George Davis,
I'm sorry, Judge.
George Davis.
Yes, Judge.
All right, this is cause number CR 24-48, State of Texas versus George Arthur Davis II. All right, let me ask a question before we get going too far on this. This will be a Chapter 62 offense, correct?
Judge, actually, no, it's being proceeded under attempted, which, if we look at, and I had that written down, but I don't have my notepad with me. Under Chapter 62, under the listed offense, it's not one of the enumerated offenses if it's not attempted. It's not A, B, C, D, E, F, K, or L. And so as such, Judge, this would not, and Judge, in bringing that up, one of my concerns is I don't know if the paperwork should reflect the degree of offense, should be, I think, a state jail, as it is being proceeded under as an attempted statute. I don't know if the court administration has sent out different paperwork, but I know back in the day when we did attempted, that would be reflected as the offense being an attempted offense, and then the degree would reflect what that new penalty group would be, which would be, like I said, a state jail offense.
Okay, I tell you what, let me run and get my penal code real quick because I want to read that for myself.
Yes, sir.
And if you're correct, then yeah, I agree with you that it would need to say attempted online solicitation of a minor degree of offense, state jail felony.
And Judge, as I said, that's going to be in Chapter 262, Section 001, the definitions under reportable. And specifically, if you look at Section G.
Hang on. Let me go get my book. So when you're telling me this, I can look at it. Hang on. Give me just a second. All right, Mr. Davis, come on back up. All right, we are back on the record, cause number CR 24-48. All right, thank you for that time, Mr. Manning. I appreciate the site to 62. All right, so I have refamiliarized myself with chapter 62, and it appears that online solicitation as identified in subsection J is not included in the subsection G, which includes an attempt, conspiracy, or solicitation. So it looks like it's specifically omitted from those classification of offenses. So that answers my question. I wanted to make sure that we were correct on that before we got over. So, all right, Mr. Davis, if you'll raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. You can lower your hand. Your name is George Arthur Davis II, correct?
Yes, Your Honor.
And Mr. Davis, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, Your Honor.
Have you had enough time to discuss the case with him and have all of your legal questions answered?
Yes, Your Honor.
Do you understand everything that you have read and signed as part of your plea agreement?
Yes, Your Honor.
And where you did sign your name, that's your true and correct signature, and you only signed once you understood what you were signing. Is that correct?
Yes, Your Honor.
All right, Mr. Manning, do you believe Mr. Davis to be competent? And if so, that he's entering into this plea intentionally, knowingly, and voluntarily?
I do, Judge. Mr. Davis was able to discuss the particularities of his case prior to us receiving discovery. He was able to interact with me as we looked at the discovery, provide explanations, as well as discuss the law and questions he had. So I do believe he's competent. I do believe he's entering into this plea intentionally, knowingly, and voluntarily.
All right, Mr. Davis, you are charged by indictment with the third-degree felony offense of online solicitation of a minor. I see that the plea agreement today is that you would plead guilty to an attempted online solicitation of a minor, which would lower the range of punishment to that of a state jail felony offense, which carries a range of punishment of not less than 6 months or more than 2 years confinement in prison, should you be revoked from community supervision and sentenced to prison time. I see that in your agreement here that you would plead guilty to the attempted commission of that offense. In exchange, the state's recommending that your punishment be assessed at 5 years community supervision and a $1,000 fine. In addition, you would have reimbursement fees of $520 and court costs of $290. Is that your understanding of the plea, Mr. Davis?
Yes, Your Honor.
All right, understanding the plea agreement and the range of punishment, did you and Mr. Manning discuss the advantages and disadvantages of a deferred adjudication plea?
Yes, Your Honor.
And you understand that if the court approves this plea agreement today, and if you at a later time violate any of the conditions of your community supervision, the state of Texas could file a motion to bring you back to court. And if they do so and then put on evidence that proves to the court that you have violated any of these conditions, the court could do several things, including convicting you of this offense, revoking your community supervision, and assessing you prison time from the minimum 6 months all the way up to a maximum 2 years. You do understand that?
Yes, Your Honor.
And understanding that, you still wish to go forward?
Yes, Your Honor.
All right, Mr. Davis, then how do you plead to attempted online solicitation of a minor?
Guilty, Your Honor.
Are you pleading guilty to that lesser charge because you are in fact guilty of committing that lesser charge?
Yes, Your Honor.
Did anybody threaten, force, or pressure you to plead guilty here today?
No, Your Honor.
All right, the court will accept Mr. Davis's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection to state's one.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Nothing from defense, Judge.
All right, court's going to review the stipulation. All right, so counsel, just I'm reading the stipulation. I want to make sure that I have a full view of the evidence to show the attempted offense. Is the state's prosecution based on the agreement to meet with the individual? Was there?
There were other substantial steps, Your Honor. I just didn't want to get into the weeds, so to speak, but there was a photo that was exchanged via text. And there were some rather salacious statements that were made, all leading towards that agreement to meet.
Okay. And you agree, Mr. Manning, that legally Mr. Davis has committed attempted online solicitation?
Judge, we've discussed the legal standard, and I explained to him that the state has to prove some action that was in furtherance of the online solicitation. We discussed his remedies with a trial, whether before the court or for the jury, and he accepted this offer as it was in his best interest.
Okay. All right. Then based on the court's review of the evidence, I find that there is sufficient evidence to convict George Arthur Davis of attempted online solicitation of a minor. The court will follow the agreement between the state and the defense. The court hereby defers a finding of guilt on attempted online solicitation of a minor. Court places Mr. Davis on 5 years community supervision deferred. The court orders him to pay a $1,000 fine, $290 court costs, $520 in reimbursement fees. And state, if you can make sure that the order of deferred adjudication reflects that the offense is attempted and that the degree of the offense is a state jail felony.
Judge, I can
Yes.
attest that we have received updated paperwork while the plea was going on that does reflect that it was attempted and the degree of offense is state jail.
Excellent. All right. Thank you very much. I do appreciate that. All right, Mr. Davis, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. After that, the probation officers will give you more info.
Thank you, Your Honor.
You're welcome.
Judge, I have Mr. Valencia's paperwork. I just need a couple moments to go over it with him and then we'll be ready to do his plea.
Okay, very well.
Thank you.
Mr. Manning, you ready?
I realized after I answered you in the affirmative that you couldn't hear my answer, so I apologize.
Well, it's okay. I thought you were still talking with someone else off camera, so I was like, well, I'll just wait for him to be ready. And I had a text from Patty, but it was an older text, and so I was like, I don't know if he's ready or not. We'll just find out.
We were ready, Judge.
All right, let me see. This is on Mr. Valencia.
Yes, Judge, and I would like to thank Ms. Curry and her office. I apologize on this one. I had spoken to my client about the possibility of doing this offer. Ms. Curry had extended that, and I never gotten back to her on that. So I appreciate her and Ms. Abney being able to do the paperwork on the fly. I know that's usually against policy, but they did accommodate Mr. Valencia.
Yeah, noted. All right, so tell me what we're doing today, because I don't have any paperwork.
Yes, Judge. So Mr. Valencia has three charges. Well, he has 4 different counts. 2 have been indicted. So CR 24, 81, and 82. He was indicted on both of those charges to have assault, family or household member impeding breath or circulation. Both of those were indicted for an offense that happened back in January of 2024. One in CR 2481, that offense date was January 20th, 2024, and in CR 2482, that offense date was January 25th, 2024. In 81, the plea agreement is that upon a plea of guilty, punishment is going to be assessed at 8 years TDCJ, probated for 5 years. There's a family violence fine of $100, and that will run concurrent with CR 2482. The court cost for that is $290, and there is a $20 reimbursement fee. In CR 2482, upon a plea of guilty, punishment is going to be assessed at 8 years TDCJ, institutional division with that's going to be probated for 5 years. There's a fine of $2,500, which includes a $100 family violence fine. The time is going to run concurrent with CR 2481, and state has agreed to 1245 reject DA unfiled DA 2024-0120, which is an unlawful restraint, and DA 2024-0118, which is an assault causing bodily injury family member. As I said, the fine on that one is $2,500 and court cost $290. There's a $520 reimbursement fee on that.
All right, thank you. All right, for the record, this is cause number CR 24-81 and CR 24-82. Mr. Manning, did you say you said that there were 4 counts, and so those other ones are what's being 1245, is that correct?
That is correct, Judge.
All right, this is State of Texas versus Ezekiel Alejandro Valencia. Mr. Valencia, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir,
All right, thank you, sir. You can lower your hand. Just make sure you speak up loudly and clearly so I can hear you, and so my court reporter can type down what you're saying. Mr. Valencia, are you a United States citizen?
yes, Your Honor.
Do you read, write, and speak English?
Yes, sir.
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning?
Yes, sir.
Like you've had enough time to talk with him about all of your cases and that you've had all of your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed that you do not understand?
No, sir.
Where you have signed the paperwork, that is your true and correct signature, correct?
Yes, sir.
And you only signed that paperwork because you were confident you knew what you were signing. Is that correct?
Yes, sir.
And Mr. Valencia, have you ever been diagnosed with any type of mental condition?
No, sir.
Mr. Manning, do you believe Mr. Valencia to be competent? And if so, have you explained to him his rights and that he understands what he's doing today and entering into these plea agreements intentionally, knowingly, and voluntarily?
Yes, Judge.
All right, Mr. Valencia, you are charged by indictment in cause number CR 2481 of assault of a family or household member by impeding breath or circulation, a third-degree felony, which is the same charge in cause number CR 2482. Both charges carry ranges of punishment of not less than 2 years or more than 10 years confinement in prison, and also carries possible fines not to exceed $10,000. I've heard the plea agreement announced by your attorney, Mr. Manning, and he's indicated that you are, in your agreement today, going to plead guilty to each one of these crimes in exchange for the state's recommendation as part of their agreement to recommend that the court consider the evidence, convict you of each one of these offenses, sentence you today to 8 years confinement in prison, but the court to suspend that 8-year prison sentence and place you on 5 years of community supervision, along with fines, court costs, and reimbursement fees. And the state would not further prosecute you on the assault, family violence, and the unlawful restraint. Is that your understanding too, Mr. Valencia?
Sir.
All right, Mr. Valencia, any questions before we go further?
No, sir.
Okay, Mr. Valencia, then how do you plead to assault of a family or household member by impeding breath or circulation in both cause numbers, CR 2481 and CR 2482?
Guilty.
Are you pleading guilty to each one of these crimes because you are in fact guilty of committing crimes in each case?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt in each case respectively. Mr. Manning, any objection to the stipulation of evidence?
No objection to state's one in both causes.
All right, stipulation of evidence is admitted and the court takes judicial notice of Mr. Valencia's judicial confession. Is there anything further from the state?
Your Honor, just that the state is in compliance. Victim impact statement was provided, was not returned. Normally we call and try and double check. We weren't able to get that done this time, but we are in compliance, Your Honor.
Thank you, Mr. Hartwell. Anything further from the defense?
Nothing from defense judge.
All right, Mr. Hartwell, can you assist the court in reading the stipulation of evidence into the record? Or,
Yes, Your Honor.
or Mr. Manning, if you want to hold it up for me to read, whichever one's easier for you, gentlemen. Is the stipulation going to be the same in each case?
Judge, with the exception of the date, I believe, yes, they're very similar.
All right, I've reviewed 81. Thank you. All right, 82. A little closer, so we can kind of focus. Let's see, and maybe back it up a little bit. For some reason, it's really. Oh, there we go. Perfect. All right. Did you say there's different victims? This one says Leslie.
No, judge. No, judge. I said different dates.
Different offense dates. Okay, my apologies. Okay. All right, then upon reviewing the evidence, the court finds that there is sufficient evidence to convict Mr. Valencia of each offense. The court follows the plea agreement and recommendation of the state. Court hereby convicts Ezekiel Alejandro Valencia in cause numbers CR 2481 and CR 2482. Court finds that the agreement and follows the agreement. The court sentences Mr. Valencia to 8 years confinement in the Texas Department of Criminal Justice. The court will suspend those sentences today, place Mr. Valencia on 5 years community supervision. The court orders him to pay a $100 fine in cause number CR 2481, along with court costs of $290 and reimbursement fees of $20. Court runs that case, the sentence in this case, concurrent with cause number CR 24-82. In CR 24-82, the court also assesses punishment at 8 years confinement in prison. Court suspends that sentence for 5 years community supervision, orders a $2,500 fine, $290 court cost, $520 reimbursement fees. The court dismisses and takes into consideration under section 1245 DA cause numbers 2024-118 and -120, assault, family violence, and unlawful restraint, respectively. The court dismisses those as taken into consideration. Mr. Is there any victim protection conditions in the conditions of community supervision? Is there any? Go ahead.
I did not see any in my review of them. I reviewed one pack and read it to him while he was reading the other one, so it may have been the other set of paperwork. I would have to review.
Ms. Burns, do you know, is there, or Mr. Hartwell, is there any prohibition, contact prohibition with the victim, or the victim and defendant still together?
Your Honor, I'm unsure. What I can tell the court is that on both of the offense dates, Miss Elwood was not wanting to press charges. Officers made the arrest over her objections. But that's the only information that I could give the court. I don't know if there's anything current. Obviously, that was 6 months ago. So I don't know what the current status is.
Mr. Manning, go ahead, Ms. Burns.
The referral that was sent to us from the DA's office did not have any additional conditions, special conditions, so we didn't put any special conditions on it.
Okay. Mr. Valencia, do you intend to continue a relationship with the victim in this case?
No, sir.
Do you and she have children together?
No, sir.
Okay, and so you're not currently in a relationship with Miss Elwood? Okay. All right, the court hereby remands Ezekiel Alejandro Valencia to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Mr. Valencia, I'm gonna have you step over to be fingerprinted with the deputy, and then the probation officers will give you more information.
Judge, last but not least, I have Mr. Ertzberger.
All right, this is cause number CR 24-69, State versus Jacob Thomas Ertzberger for pretrial. Go ahead, Mr. Manning.
Yes, Judge, we reviewed the discovery. It appears we're missing a video. My client reminded me of that. I had we discussed that in my last meeting with him. And I'm waiting to get an offer from the state on this. I believe Ms. Curry is handling this case. So if I may have another pretrial to discuss both missing video as well as continuing negotiations on his case.
Any objection from the state?
No objection, Your Honor. If we know which videos the defense does have, we'd definitely be able to narrow that down to make sure he gets the missing one. But we can handle that outside of court, Your Honor.
All right, court will set Mr. Ertzberger for an additional pretrial on July 11th. Is that enough time, Mr. Manning?
Yes, Judge.
July 11th at 1:30.
Your Honor,
Yes, ma'am.
can you look back on page 6? I don't believe we took care of Mr. Hubbard this morning.
The key one that was in Florida.
No, sir.
No, well, he didn't show up, so we'll have to do a nice eye. I called his name and he did not answer, so. Yeah, court's gonna call his name loudly, distinctly 3 times before I conclude today, and we'll issue a judgment nice eye. And then there was another one that we didn't discuss that was in custody, I think in Florida.
Yeah, that was Mr. Pryor on page 3.
Yeah, I don't think we discussed that with anyone, but I went ahead and reset that one for status. No, actually, I haven't set that. So I got a note here that says that we do have a detainer on him. He's unrepresented. So let's just keep that on the docket. It's a motion to revoke. Well, let's kick that out to, let's put that on August 1st. And we'll do status of custody. And then we'll let the state decide if they want to, if we need to bench warrant him.
What about Mr. Richardson? Did we talk about him?
I think we reset.
Christopher Richardson on page 12.
No, we haven't called him yet. I show these verified in Smith County, so we'll need to. This is cause number CR 23225. We'll reset Mr. Christopher Michael Richardson. Do you have any information on him, Mr. Manning?
Judge, sorry, they got my folks all over, and I don't know if they're on our holds, on other people's holds. I think Mr. Richardson was over there. Judge, I'd be lying if I said right now, I don't rightly recall, but I believe he had some business in Smith County. I don't know. If he's the one that I'm thinking of, I think he was set last month. We were waiting for disposition on him.
Yeah, that's correct. That's correct. All right, let's set him over to August 1st. And we'll do status. Custody. And I'm sorry, Mr. Abraham, we already have a warrant out for Mr. Manzanares, correct?
Yes, Your Honor.
We don't have that under advisement on our hold, correct?
No, Your Honor.
Okay, good. All right, is that everything on the docket?
I believe so.
Is
All
that
right.
business, may I excuse?
Yes, thank you, Mr. Manning, and Ms. Abney, thank you for getting those plea papers done that Mr. Manning appreciated as well. So thank you for getting that done so we could get Mr. Valencia on his way.
All right,
right.
we'll see you back at the courthouse.
All right, if there's nothing further, then I'm going to have the name Timothy Wade Hubbard called loudly and distinctly 3 times in the courthouse. If there's no response, then the court's going to issue a judgment not signed alias capias. If there is a response, then I will let everyone know.